Mr. West, as I've been calling you and you haven't corrected me, I'm very, very, very sorry. It's the heat. That's all I can say. We've taken the lead of council. It is really, really hot, and we're very sorry about that. There's an air conditioning unit that's been delivered. I don't know if it's going to be so noisy that we have to turn it off eventually, but we can't plug it in because of health and safety. So we will wait for somebody to come and do that. But my lords and I agree that, given the circumstances, if you would like to take your jackets off, and you would feel comfortable in doing so.
I think I'm all right personally.
Yes.
The invitation is being accepted.
Yes. And if you change your mind.
Thank you. Thank you very much, my lady.
Please do.
Lady, without taking the court back to it, I should have referred to paragraph 58 of Lord Phillips in the Christian Brothers case, because he says, in relation to the facts of that case, neither of these differences, having gone through the distinction between the brothers and a conventional employee, neither of these differences is material. Indeed, they rendered the relationship between the brothers and the institute closer than that of an employer and its employees. So one has to be careful, I would respectfully submit, in taking passages from cases where the facts are so very different and giving them an extended reach into a completely different factual scenario. And turning back just briefly to the question of control, Mr. Roper's scouting activities, there's no evidence Blackpool Football Club had any control over where he went, could direct him where to go, who to watch. They had no right of preemption or right of first refusal of any of his good players. They were entirely dependent on him volunteering and persuading a player and his parents to have a go at getting signed by Blackpool Football Club. And if, as the judge found was the case, as he put it, the club lavished rewards on him, that merely underlines the point that they had to behave in that way, because that's how, as a fourth division club, they wanted to make sure that the good players kept coming. And it far from making him an integral part of it, it merely emphasizes the lack of control they had over his activities. And turning to the trip, the New Zealand trip, that was a matter between the parents and Mr. Roper. It was entirely incidental that one of them, namely the claimant, was entered into the Blackpool Football Club School of Excellence. On the judge's analysis, as we understand it, the club would have been vicariously liable if Roper had abused one of the other boys on the trip, one of those who had nothing to do with Blackpool Football Club. That's the logic of the conclusion that the judge comes to. And the club had no control over Roper and that trip. He had the funds to pay for it. The club couldn't stop him doing it. Mr. Ellis might have said, "I'm not sending my son." Any parent might have said, "I'm not sending my son on that trip." But there was no way the club could say, "We don't like the look of this, so Roper, you're not going to take anyone on this New Zealand trip," unless that person was someone over whom the club itself had control, such as one of their apprentices. Now, I accept that 4 apprentices did go. They were there apparently as part of the continuation of their attending these trips, 8 or 9 of them, as Nova Junior players who knew Roper anyway. But there was no control that could be exercised over Roper in any other respect. And just finally on this point, Sam Ellis's witness statement, at paragraph 6, I did read this out, said that Jack Chapman had a wide-ranging contacts who he worked with, including Frank Roper. He was just one of the contacts, as it was put. You can call them scouts, you can call them those who run junior clubs, Chapman, as the youth development manager, kept in touch with. But that's the extent of it. Graham Wright was a witness who I think played for Nova Juniors, and he described, if I could just give one final reference to the transcript, at page 95, the transcript bundle.
Is he anonymised?
No, he's not. Well, he wasn't. I don't think he
No.
Well, 97, 96 first of all, he's playing for Nova Juniors, and just below letter A, I think we played in whatever kit Nova played for. I do remember he liked us to play in the Blackpool football kit, which was tangerine, he explains. On 97, middle of the page, he used to take us to at Blackpool Football Club to games and wear the football kit. Again, this is Roper's preference, although very oddly he doesn't pursue that preference when he's apparently taking a Blackpool football representative side to New Zealand. But at letter F, he says he refers to a scout called John Thompson, who was a scout for Coventry. And he explains that he was a teacher over the page, and he met him at his school. He was his PE teacher, sports teacher. And he had a connection with Coventry, yes. Did he have connections with other clubs? Not that I'm aware of. But he was a full-time employee, a full-time teacher. Yeah, he was a full-time teacher or on a part-time basis scout at Coventry Football Club. Then he refers to Mike Walker, who was a manager of a junior club, and described him as a York City scout. Is it being suggested that the Coventry City Football Club would be liable for the torts of a teacher, PE teacher, who referred one of his pupils to them, or York City for I think it was a taxi driver, Mike Walker, who was a scout? These are examples of the wide-ranging contacts of the sort that Mr. Ellis refers to. And Mr. Ellis also says that it was Mr. Roper who would refer players if he wanted to. I think that's in his witness statement. Ellis's witness statement. It may have been, I may be mistaken, it may have been in the transcript of his evidence, but he referred to the Roper, if he wanted to or chose to, he could refer players to them. And that was the nature of the relationship as described by Ellis. Turning now to the second stage of vicarious liability, I've added to the bench, because it probably should have been included in the authorities, Lister and Hesley Hall, but only to make one short point. The reason for this is, as we see, Lister is the case that takes forward the issue of vicarious liability applying Canadian authority guidance in Canadian cases. Dubai Aluminium then relies upon Lister, and a series of other cases then build on those. So this is as it were the starting point. And the point here was this was a boarding house attached to a school, and it was the warden of the boarding house who committed the sexual abuse. I just wanted, there are large quotations from this in Lord Phillips' judgment in the Christian Brothers case, but can I just take you to one part of Lord Millet's judgment which Lord Phillips doesn't quote, which is right at the end, paragraph 82, which is the penultimate page. And this is, therefore, stage 2, the connection. In the present case, because the warden, they dispute the warden was employed, in the present case, the warden's duties provided him with the opportunity to commit indecent assaults on the boys for his own sexual gratification. But that in itself is not enough to make the school liable. The same will be true of the groundsman or the school porter. But there was far more to it than that. The school was responsible for the care and welfare of the boys, It entrusted the responsibility to the warden. He was employed to discharge the school's responsibility to the boys. For this purpose, the school entrusted them to his care. And that contrast, I'll come to in a moment where that comes from in the Canadian cases, is important in this context because, as I've said, it was merely incidental that Claimant was entered into the School of Excellence. The club owed wasn't in loco parentis to any of these children. They were living at home. The parents entrusted the children directly to Mr. Roper, so it wasn't a triangular arrangement whereby they entrusted the children to the club, who then entrusted them to Mr. Roper. And therefore he is much closer as simply a scout to someone who seizes an opportunity, like the groundsman or the porter, rather than someone to whom the non-delegable duty, as it were, is entrusted, in that case the warden. And can I then invite attention to just one part of Dubai Aluminium, which is at tab 13. Of course, this is in a completely different context. It's a vicarious liability for the equitable wrong of dishonest participation in breach of trust. But we see from paragraph 23, Lord Nichols' speech, that he builds upon Lister and Hesley Hall, and also and quotes Justice McLachlan in the Canadian case of Basley and Curry. The policy purpose underlying the imposition of vicarious liability on employers is served only when the wrong is so connected with the employment that it can be said that the employer has introduced the risk of the wrong, and is thereby fairly and usefully charged with its management and minimisation. And the only other part of this is paragraph 39, which is perhaps relevant to the second stage in this case. Just below letter D, what Lord Nichols describes as a further point. He talks about the proposition. Vicarious liability is not imposed unless all the acts or omissions which are necessary to make the servant personally liable took place within the course of his employment. So again, that requires a focus in this case of what it is that is the employment or quasi-employment to which incidents or duties are attached, and which Mr. Roper has to perform, and how far, therefore, in New Zealand, that is, which is when the assault occurs, whether that was occurring in the course of the course of his employment in that sense. And then back briefly to the Christian Brothers case at tab 16. I think it's paragraph 63. Under the heading vicarious liability for sexual abuse. Paragraph 64, Lord Griffiths refers to Basley and Curry, residential care facilities, and gives more detail. And then he says two particular principles of policy. The first was where an employer puts into the community an enterprise carrying with it certain risks, and those risks materialise and cause injury. It is fair. Having created the enterprise and the risk, the employer should bear the loss. And that's why we question whether it is enough just to describe Mr. Roper as a scout and committing a tort in the course of that employment, because a scout may be someone who is required to be put into intimate contact with children, on the one hand, or may be kept at arm's length and with no creation of risk in that sense. And what is interesting is that in paragraph 65, Lord Phillips quotes from Marcus Sinus and Deakin's tort law, describing this as the enterprise risk approach. The court had no difficulty in finding that the test was satisfied in Basley and Curry, But D1's duties under his employment by D2 included bathing the children and putting them to bed. Jacobi and Griffiths, on the other hand, the majority took a different view. D1 and D2 had met them in a club. The facts obviously didn't support it, but the point is, if it's necessary to focus on that detail, including bathing the children and putting them to bed, then it's clear that it's not enough simply to say, well, you're employed in a children's home, for example. And that brings me back to what Lord Millett was saying in Lister. And I think that's paragraph 72, I think that probably, yes. Not sure whether I've taken the court to this or not, but there's a reference there to Lord Millett saying, at paragraph 70, it was critical that attention should be directed to the closeness of the connection between the employee's duties and his wrongdoing. And refer with approval to the Canadian decisions. Then 75. He refers to Lister being applied in Dubai, and then paragraph 80 refers to a case called Macur, which is in the bundle, Archbishop of Birmingham, and he notes just below letter E, giving the leading judgment, Lord Newberger of Abbotsbury and Master of the Rolls applied the close connection test, identifying a number of factors that led to the risk being satisfied. He further held that the material increase of risk test applied in the Canadian cases was also satisfied. Lord Justice Longmore applied the close connection test and said that McLaughlin J's exposition of the law in Basley was of a material increase in risk was highly relevant. Again, what we have there, and the court can look at Macur if necessary, but an intense focus on the incidents and the particular factors in that case that made it appropriate to say that there was a close connection. Not simply saying, well, the connection is established by the first stage. There's an employment relationship, and it's sort of, broadly speaking, in the course of that employment. It has to be very much in the course of the specific duties assigned. And 86, starting with the Canadian authorities, a common theme can be traced through most of the cases to which I've referred. Vicarious liability is imposed where a defendant whose relationship with the abuser puts it in a position to use the abuser to carry on its business or to further its own interests, has done so in a manner which has created a significantly enhanced the risk that the victim or victims would suffer the relevant abuse. The essential closeness of connection between the relationship between the defendant and tortfeasor and the acts of abuse thus involves a strong causative link. At 87, these are the criteria that establish the necessary close connection between relationship and abuse. I do not think that it is right to say the creation of risk is simply a policy consideration, not one of the criteria. Creation of risk is not enough of itself to give rise to vicarious liability, but it's always likely to be an important element of the facts that give rise to such liability. So again, we say, well, what is the evidence? What are the findings as to how far and to what extent, and relevantly to this case, was there the creation of a risk? Certainly not simply appointing someone as a scout, if that's enough to satisfy the first stage of vicarious liability. And we say not even enough when he's not taking children to who've been whose care has been placed in the hands of Blackpool Football Club. Not enough to satisfy the test in relation to the trip to New Zealand. And that brings me to the recent data protection case, very different facts. But this is tab 20. So this is a mischievous employee who's entrusted with data for proper purpose, but then chooses to copy it, personal data, in breach of data protection legislation and uploaded it to a publicly accessible website to cause harm. In fact, harm to the defendant, as well as no doubt harm to the people whose data it was. And the Supreme Court were unanimous in saying that he was not acting in the course of his employment. But what will be noted, and has been noted by my learned friends, is that at paragraph 23, having referred to Lord Nichols and aluminium, below letter E, as Lord Phillips noted in Catholic Child Welfare Society, the close connection test has been applied differently in cases concerned with the sexual abuse of children, which cannot be regarded as something done by the employee while acting in the ordinary course of his employment. Instead, the courts have emphasised the importance of criteria that are particularly relevant to that form of wrongdoing, such as the employer's conferral of authority on the employee over the victims which he has abused. And Lord Reid is not saying that there's a completely separate category of vicarious liability in sexual abuse cases. He's merely saying that it has to be, you have to focus on the particular way in which the risk is created and the conferral of authority on the employee over the victims by the employer. How is Blackpool Football Club conferring authority on Mr. Roper to over these children whose parents have entrusted him with their care during the trip, and who is paying for the trip himself? Can't be enough that there's a small donation made or some sort of club approval. And in any event, at paragraph, I ought to say that my skeleton argument, I accept responsibility for this, was misleading in one respect. I said that the argument that was rejected was stated in paragraph 18. In fact, in paragraph 18, Lord Reid is quoting from Lord Toulson in Mohammed, which was the petrol station assault case. And it was letter, just below letter F. The argument in the appeal to this court, so he was referring to the appeal in that case, was that the test of vicarious liability should be broadened so as to turn, in the case of a tort committed by an employee, on whether a reasonable observer would have considered the employee to be acting in the capacity of a representative of the employer at the time of committing the tort. The court rejected that argument. So I was wrong to say that argument was only put to bed after Mr. Justice Griffiths' judgment, but it remains the case that it is not it's not enough. And yet these claimants and the claimant and his witnesses repeatedly talk about what they understood to be, they inferred was the position, the impression they had about Roper and his relationship with the club, built largely upon what he was saying and understandings and impressions, rather than any clear representation by the club, let alone an objective analysis of how it was that the club, that Roper was under the control of the club and was acting effectively as a member of their staff. Paragraph 26, Lord Reid notes that Lord Toulson was not suggesting a departure from the approach adopted in Lister and Dubai Aluminium. The exact opposite. I think, my lady and lords, that's all I need to take the court to in the authorities on vicarious liability. Mohammed, I haven't taken the court to, but it is a slightly different situation, but it's sufficiently seen from Lord Reid in the recent case what was going on there. And can I then move on to where we say the judgment is inadequate in response to that case law, part of it, of course, case law that didn't exist at the time of the judgment, and in response to the facts generally, without laboriously going through the judgment. At paragraph 123, it seems that the judge was making something of Michael Davis, who was a rather older figure. He'd been an apprentice from 1982. Paragraph 123, page 103 of the call bundle. He said, interestingly, that in his time as a schoolboy in the early 1980s, there was no centre of excellence at Blackpool. The rules required any centre of excellence to be officially registered and approved. The lack of a centre of excellence at Blackpool to cater for potential signings before they reached the age of 14 were eligible to sign schoolboy forms makes the informal arrangements in place to spot and recruit boys between the ages of 11 and 14 more important. It's clear from the evidence I have cited that Roper was an important part of those arrangements. However, there seems subsequently to have been something that was at least called a Blackpool School of Excellence, which the claimant DSN attended in the late 1980s. Well, that's a paragraph, we respectfully say, which, as it were, contradicts itself at the end, because having made the point, apparently, that was seeking to make the point, we infer that Roper was needed because there wasn't a school of excellence. He then notes rather, just at the end, that there was a school of excellence, it seems. Well, there clearly was. That was the claimant's own evidence. There was a school of excellence, and he was registered with it. So if it's important that Roper's relationship with the club was needed because there wasn't a school of excellence, then the answer is there was at this time. So that doesn't lead anywhere. Paragraph 133 the judge is describing the claimant's evidence about Roper. I think I got that right. Talks about Roper, Claimant working in Roper's shop. I think I've got the wrong reference there. I'll move on. Paragraph 134, the judge draws an inference. The 5 lines down, I infer that he used the New Zealand trip partly as a means of drawing boys in to join the Fresh Nova Juniors, which was itself a means of bringing them to Blackpool FC until they reached the age when they could be formally signed up and tied in. DSN said, I understood Nova was based in the Blackpool area for people who had been on the tour. Well, lady and lords, 2 problems about that. Firstly, the Nova that DSN was talking about didn't exist at the time of the tour. It came into being afterwards. Secondly, this is entirely speculative. There's no evidence. And the judge simply says, I infer he used it. Well, he might have been able to tell us, but certainly there was no one to describe what his motivation was. All we do know is that he didn't flag up or advertise any connection with Blackpool Football Club.
Could you just clarify something for me, Mr. Kent?
Yes.
I think it won't be the last time. As I understand the evidence, there was a Nova Juniors team.
Yes.
There was then another team which was called Nova Junior, and there's a suggestion that the new team was started by Roper because the people who were involved in the old team had worked their way through the age group or something like that. Have I got that wrong?
Well, it was all very unclear. The reference to the new Nova in Blackpool seems to come from Frank Sharp, and whose son was invited but decided not to join it, and he went on the New Zealand trip. That's about all we had about it, I think. There was very little.
Put at its highest, both were or were not teams which Roper ran, and if he saw someone who he thought was a talent, he might then recommend them on to someone else.
Yes. Well, I think that the judge was entitled to draw that.
Is that?
Yes. That would be open to the judge. And
but in your submission, that's as far as it goes.
Yes, exactly. Lord, I was looking for a reference where the judge said that Roper brought boys to the club. Where, quite a few, I'm told. But of course, Roper, like any scout, could offer them. Chapman was the man who made the decision. That's made clear by Sam Ellis. But using that sort of language enables one to slip into the idea that he was part of the workforce, part of the staff, but he clearly wasn't. Then, at paragraph 159, the judge... Which one? Oh, yes. Yes, I think it may be in 159. In paragraph 159, the judge notes, and this is a conclusion on stage 1, Roper was an unpaid volunteer, the fourth line, but the club's dire financial state meant that almost all the non-playing staff were in the same position. Chapman could not and did not do his job alone. He depended on people like Roper and Hurst to help him. And then dropping down, it becomes a Blackpool feeder team. And there's the reference to the closed environment, in which Blackpool had a better chance than any other club of securing their signatures. Well, again, no evidence that Blackpool had any right of first refusal. And then there is, I'm told there's a reference to Roper bringing, yes, right at the end, both quality of the young players he brought to Blackpool. Well, it depends what the judge meant, but all he can do is offer. In the way that any tradesman might be offering goods or services to the club. And to equate Roper with Hurst, when Hurst was a volunteer, but he was given assigned duties as a physio, a coach, an assistant coach, and an assistant scout, told where to go, when to go, coming along every Tuesday and Thursday after work, after his job, Saturdays as well. To say that has any connection, any resemblance to the role of this independent free agent, Mr. Roper, who chooses or to give or withhold promising players to the club, is to make a completely false connection or analogy in our submission. The crucial point, again, is that the club exercised no control over Roper. He did what he wanted. And in fact, there's evidence that Hurst got paid expenses. Judge says, I mentioned the lavishing tickets, paragraph 170, or Mr. Ellis said they couldn't give the tickets away. 161, the judge says that the second line, Blackpool FC could have removed Roper's access and all the other incidents of his position with Blackpool FC had a stroke, and if it did, Roper would have been nothing. He depended on Blackpool FC even though he was not employed by them under a contract. Well, my lady, my lords, first of all, they could have done, but that's true of anyone who might want to do business with the club, or any fan who might want to attend. It doesn't of itself establish the necessary relationship akin to one of employment. In any way, in any event, he wouldn't have been nothing. He had his own business, or businesses, as well as running his own junior club. And of course, he could have then, if he wanted to, offer good players to other clubs. So that, with respect, does not really assist in saying this was a relationship akin to one of employment. And I've already said at the end where he says Nova Juniors was not an independent club is based on no evidence at all. This ignores the copious evidence that Roper had his own business. It ignores that Roper's boasting of his ability to get players signed by Blackpool. And it's merely saying that because Roper made himself useful, that somehow the club, in not banning him, was accepting that he was on the payroll, in inverted commas, when clearly he wasn't. to say that Ellis endorsed the trip is not enough. It's not sufficient that a reasonable observer would have considered Roper to be acting in the capacity of a representative of the club. In any event, Johnson wasn't sure which trip the £500 donation went to, but even if there was an endorsement and a small payment, does that mean that the NEC, who were sponsoring Everton, for example, were become liable for the torts of players at Everton? Or if a donation had been made to local schools, would Blackpool Football Club become liable for their for the torts of the teachers? It becomes a never-ending prospect if simple endorsement is enough. I think I've probably said enough about the findings, except the judgment at paragraph 175, conclusion on vicarious liability. The judge says, and I've already referred to this, 5 lines down, this is close to an official trip has made no difference. It was the football tour that was part of Roper's operation in building the allegiance of promising young footballers to Blackpool Football Club. But what is the evidence for saying that he built an allegiance when the trip, and he's talking about the trip, it was conspicuous by the absence of any references to Blackpool Football Club or any insignia or badges or shirts or anything to tell the world that this was connected to Blackpool Football Club, or therefore that built allegiance on the part of the boys who he had selected from the Fylde coast, such as Forrester and Kevin Sharp, neither of whom joined his Nova team, and both of whom went off to eventually to I think quite a well-known club in France, Auxerre, and then to Leeds United to pursue professional careers. There is no evidence that it was building allegiance. All the evidence is that he was, for his own purposes, probably business purposes and possibly nefarious purposes, was getting some boys to go on this trip, which he was prepared to pay for. And so, in any event, the key point is that Mr. Ellis says it was not a Blackpool Football Club trip, as did Mr. Hurst, as did Mr. Johnson. So, key omissions from the judgment are these. Firstly, the judge doesn't say anything about the underlying purpose of Roper's New Zealand trip, or indeed his series of trips, 8 or 9, starting with American trips. The most we get is a reference in paragraph 174 to Bradshaw's evidence about bringing back some Lacoste labels, but all he says about that is that they were sold on their own account when they were back at school in England, as if it was a perk for the boys. No reference to the massive container of material which Bradshaw himself in paragraph whatever of his 18, I think, of his witness statement referred to. 25. There is the marginalisation of Mr. Hurst, despite being described as Mr. Chapman's right-hand man, and by Mr. Ellis, as if his evidence provided no particular assistance. There is no reference to the pleaded case that this was a trip for the School of Excellence. And as I've said, the repeated references simply to what was in the claimant's witness statement, paragraph 20, that it was a trip organised for the boys in the School of Excellence, with no reference to the way in which that was heavily modified and qualified, and in effect negated by the claimant's own evidence, and the fact that there was no one apart from himself and possibly Tim Ellis from that School of Excellence. No reference to the British Airways itinerary, describing it as Frank Roper's tour. How that is building allegiance to Blackpool Football Club isn't clear. No reference to the New Zealand Herald article. No reference to Bradshaw explaining that he had been driven over 18 months to Manchester United, and Roper had referred 2 additional Nova players to that certainly a very well-known club, and way up in the first division in those days, compared with Blackpool in the fourth division, I think. And no reference to the colour photograph or the fact that they were wearing Everton away kit, or the fact that the apprentices who attended had gone along, as Mr. Sharp explained, having discussed it with them on previous trips as part of Nova Juniors. And indeed some of them were connected to Roper in any event through his shop. And one of them was, Roper lived with his parents. Turning to limitation, I'm going to take this very shortly because we set it out in our skeleton argument. And the first ground is put forward as a perversity ground. And that's we accept that is a high threshold to come to this court to say there is perversity. But we do say that, and I've explained at the outset that the only explanation we can think of is that the learned judge took the view that a much simpler approach to vicarious liability would be sufficient. Because the two main protagonists, Roper and Jack Chapman, are no longer with us. And incidentally, I think my learned friend says that Roper would have disappeared in any event shortly after this trip. In fact, in the trial bundle, there is the supplementary bundle, the death certificate of Roper at page 138, which shows that he died in September 2005 in Heald Green, and his usual address was... Yes, but, Stockport.
Mr. Kent, no one's going to call Mr. Roper, are they?
Well,
no one in their right mind is going to... You're not going to call him for Blackpool. The claimant's not going to call him to say he abused him.
Well, abuse, I accept. That's a separate point.
Let's be real. You can't call him without opening him up to the abuse allegations.
Well,
no one is ever going to call. I'm sorry, this is maybe a sort of Wednesday afternoon reaction, but you'd be off your head to call him, wouldn't you?
No, not at all, my lord, because for two reasons. Firstly, he would probably be a defendant or a third party. He's a wealthy businessman. Secondly, he would have no partisan interest in the issue of vicarious liability, because he's going to be liable himself personally, whether the club have secondary liability. And thirdly, there are questions that one simply shouldn't speculate, we submit, as to what someone might say. The judge did this about the question of the abuse, and that has been...
But if you can't speculate about what someone might say, how can you then found a case that says that their absence is essential?
Oh, but for the very reason. We refer to Mr. Justice Nicol citing Sir Robert McGarry about the open and shut case that turns out to be far from. And Mr. Justice Nicol was saying, well, even in that case, the abuser is dead, but we just don't know what... Now, that was an issue about the abuse itself. But where you have an issue about the relationship, you have the potential for documents that might be disclosed. You have the potential for forcing them to answer questions in advance. And you can cross-examine them. Someone can. I mean, there are various ways in which the evidence of the relationship could be got out. And the defendant, who is sought to be made vicariously liable, shouldn't be put in the position where a court says, well, you wouldn't have got anywhere with that witness anyway. The answer is we just don't know.
Well, presumably, Blackpool wouldn't have been named as a defendant if Roper was still alive.
But depending on how good he was for the money, I suppose, costs and so on. Yeah. That could well be true. I suppose that's an aspect of prejudice. I hadn't thought of that. But our main point is Jack Chapman. But we don't overlook Roper because they are the two. They're the two who would know above all else what the truth was. One shouldn't assume, therefore, that a witness is going to lie and not tell the truth. And our prejudice point doesn't depend upon knowing what they would have said, but simply saying they would have had something important to say on the issues. That's where we're prejudiced. We don't have even that possibility, including documents they may have had. For example, documents Roper might have had relating to the New Zealand trip. Correspondence with British Airways saying, well, what's all this about, Mr. Roper? You know, what's this trip for? Yes. Yes, as Lord Brown said in A.V. Hall, it's always the ability to investigate, which is central to the question of prejudice. But Jack Chapman, everybody says he's the man, he's the youth development man. He is the person who it is, the claimant's case, was effectively saying, well, he was just a puppet of Roper. He might have had something to say about that. But certainly we would have been able to know why, one way or the other, whether Roper's activities were an integral part of the Blackpool business model, as it were. And so he would be a central witness. And we had in his place, doing his best, Mr. Hurst, who was a part-timer, age 81, and giving evidence to a difficult video link. On the authorities, can I just point out, they're all in our skeleton, we do rely upon Donovan, the Donovan case, which was, and Lord Oliver, I think we've fully set out in paragraph I'll come to that. We set out the KR and Bryn Allen, the importance of, in these cases, very often practical matter to have limitation dealt with at the same time as the substantive matters, which is rather counterintuitive, given the question is whether a trial should take place. And Lord Justice All, giving the judgment of the court in KR and Bryn Allen, says you shouldn't determine the substantive issues first, before you decide on the Section 33 issue. And we also make the point that it isn't just a question of whether a fair trial can take place. This, I know, has been a hot topic in criminal cases, where the issue is where there's no limitation period as such, and the courts have, as I understand it, have more readily said as long as a fair trial can take place, then that's right, even if there is prejudice. But in this context, as has been said, for example, by Lord Justice Lewison in R.E. and G, quoted by us in paragraph 10 of the skeleton, whether a fair trial can still take place is undoubtedly a very important question, but it's a necessary but not a sufficient condition. Prejudice is always highly relevant, and as Lord Hope said, as quoted by Lord Justice Lewison in CD and Catholic Welfare Society, the real possibility of significant prejudice will usually determine the issue in the defendant's favour. And so you had a claim brought 22 years out of time. The court looking back over, in fact, as far as 50 years, because some evidence going back to the late 1960s. And trying to understand that matter, which would have been almost immediately answered by contemporaneous records, School of Excellence. The relationship, for example, the claim. Yes, that's right. But that's the one person who is. The rest of the notes data come in there, wherever. Oh, on the trip, maximum. Yes, the documents would have been immediately told us. All of them, none of them, or few of the others. That's one of them. But there would have been documents relating to the relationship with Roper. It is said that he was so central to the business of Blackpool Football Club. And there would have been bank statements, board minutes, relating to the payment of small payment of £500 for a trip. And we wouldn't have had this debate, for example, as to whether it was Macur or Chapman who spotted DSN and invited him to come to the School of Excellence, telling the police that it was one or the other. Lord Oliver and Johnson is the point. The point that if there is prejudice, then the defendant is entitled to reliable, even if he was already prejudiced because of an extended limitation period. That was a case where a child was injured, and the claim was brought 5.5 years after the accident, but only 6 months late because of the extended limitation period. And here, Claimant, of course, had 8 years, I think, before his limitation period expired because of his age. And then there are 22 years. But I think we've really dealt with this in ground 2. It's the first ground I'm arguing. It really derives from what I've been seeking to identify in the evidence and the authorities as to the need for people like Chapman to describe in much more detail what, if any, relationship they had with Roper, and what control, if any, they had over him, and how far there were other scouts who were in the same position, why it was that Roper was given, to some extent, free rein. Our ground 4, the other limitation ground, is, before I get to that, my learned friends refer to Kane and Francis as one of the limitation cases, and I simply point out, without taking to it, that Lady Justice Smith was there dealing with 2 cases. The Court of Appeal was dealing with 2 cases. One, in both of which liability was admitted, in both of which a prompt letter of claim had been sent to the defendants, in one of which the claim was 1 day out of time, in the other it was a year out of time, and in neither of which it could be shown there was any prejudice. One has to be careful, therefore, in that context, of taking comments by Lady Justice Smith to the effect that it's just a fair trial that matters. She made it very clear also that the issue of prejudice was highly relevant, but it didn't exist. And what we have here is real and significant prejudice. There can be no doubt about that. On the judge's approach, it appears almost to be saying, well, we wouldn't have needed, no one needed to hear from Mr. Chapman if the case had been tried in the 1980s, because he wouldn't have taken the matter any further, whereas plainly he would have been the witness on whom the greatest attention would have been placed. And then in ground 4, we complain about it's a cart before the horse point, because in effect, the judge is saying, and this may be a link to my point about whether the judge misunderstood the need for a critical analysis of the relationship and the incidence of the relationship and the way in which the abuse can be said to have been in the course of that, of discharging those duties. But we say that in effect the judge was saying, well, all the facts were one way, the primary facts were not in dispute, and therefore there's no prejudice, which it is, we say, notwithstanding the judge's warnings to himself from the authorities, amounts to saying, well, I'm going to find against you, so there's no prejudice. That's the cart before. But all we have to say is there is significant prejudice. Lady, if I could come to the question of the unagreed bundle. This, I should have said, our ground 4, we've set it out in paragraphs 30 to 37. Just to be clear about this, Lady Justice Simler refused permission on a number of grounds, including ground 1, which was a complaint that the learned judge placed no weight on some anonymised police interviews that were in evidence. The judge dealt with that at paragraph 17, and Lady Justice Simler gave her reasons for refusing permission on that ground. It's in the core bundle, page 3. Ground 1, exclusion of the whistleblower. The evidence was submitted to the judge placed in the evidence. Given that the redacted statements were anonymous so far as the trial was concerned, the testimony. Wherever the matters addressed and documents dealt with by witnesses during the course of the hearing, many of whom were cross-examined, the judge was best placed to determine what weight, if any, to afford to the different forms of evidence available. In particular, he was amply entitled to regard the identified witnesses who gave evidence and were tested in cross-examination as more reliable and to further evidence accordingly. And we say that Lord Justice Simler, as was the judge, was there focusing on the substantive issues of the case. We can't complain, therefore, and I have been careful not to make any reference to this here, dealing with the issue of the findings the judge made about vicarious liability, because those are substantive matters. If he was going to give permission under Section 33, then we have been prevented from arguing he should have paid attention to this additional material. But we also rely upon it in connection with the limitation issue and prejudice in a different way. And this is at paragraph 36 of our skeleton. And this is under ground 4, which is part of the limitation prejudice ground, where we say the defendant refers to the state of the evidence, including the contents of the statements taken and interviews conducted by the police in more detail in the section of vicarious liability below. But unsurprisingly, it demonstrates the differences of recollection about significant facts that inevitably exist so many years after the event in question. And because, as Lord Justice Old said in Bryn Allen, the court should be careful not to make any findings on substantive issues before deciding whether it is right to permit the case to proceed. What the court is doing at that point is surveying the field and seeing what are likely to be the issues and what is likely to be in dispute in the case. So if this case had been dealt with in 2 stages, Section 33 is a preliminary matter, then the police material would have just been put before the court as a series of accounts which we would have said don't match the claimant's evidence. The court doesn't have to decide which is right, but simply to note that there are differences, significant differences of recollection. And that's the basis on which we rely upon it. That's all we are seeking to do. Now, I don't need this material to make good my points, but it is an additional factor in relation to prejudice, that if the learned judge, in considering the cogency of the evidence, had taken account of these police statements in relation to prejudice and cogency, he would have been bound to say, although, for example, Claimant says Nova Juniors, or Claimant's evidence is Nova Juniors was dedicated to supplying good players to Blackpool Football Club, I note that others said something rather different. And that's our case, that other witnesses, anonymised witnesses interviewed by the police, were saying something different. I don't want to say too much about it, because the question is whether this court should admit it. But that's all we are seeking to do with it. But it is an additional string to our bow on the question of prejudice.
Can you remind me which part of the judgment deals with that?
Yes. It's paragraph 17. It says right at the beginning. Thank you. And it's under the heading "The Evidence." There were 2 lever arch files of documents, including some redacted anonymised statements. In the course of a police inquiry, however, since they were anonymous, incomplete, and could not be tested, the matters they dealt with were more reliably and directly addressed by a number of witnesses. I do not place weight on them. Perfectly, we're bound, in view of Lady Justice Simler's refusal of permission, we're bound by that in relation to the substantive issue. But he doesn't. It's not part of his. It's not mentioned again in relation to prejudice, which is the section.
Sorry, I interrupt you. The judge takes a more general point, which is that there were plenty of other witnesses out there if you'd wanted to call them. I can't remember the paragraph number, Mr. Futrell will know the paragraph number straight away. But with these witness statements, I know they were anonymised, but do we know whether any attempts were made to identify these people?
Well,
or was a Civil Evidence Act notice put in saying they couldn't be found despite reasonable
No,
inquiry?
what happened was there was a third-party production order made against the police, the police, whoever they were, Greater Manchester Police, with the permission to redact as the police thought fit, and they redacted the names. Now, I don't think any attempts were made to go behind that. That was the fact. I mean, that was the state of it, and we cross-examined witnesses on the basis of some of these statements. One of them was the claimant's own. You could refer to that, obviously, that's a different matter.
Well, that you obviously managed to identify, but the attempts made to identify other people.
Yeah, I think mostly they couldn't be identified, but there were some guesses made as to who they were. But
and what are we to make of the judge's assertion, which I think it is, that there, as a result of inquiries you had made, there would have been other people, as it were, of the same ilk as the young footballers?
Yes,
I'm
sorry.
If you'd wanted to.
Well, we do comment on that, and I can't remember which paragraph in our skeleton, but we say, well, that's the defendant hasn't overturned every stone on the beach, and therefore can't complain about prejudice. When the elephant in the room is that Jack Chapman isn't there, and we're dealing with matters years after the event, records are destroyed. And the judge was saying, we could have gone after these players, these other players. But how is a player going to help us, who would have been a boy at the time, with the relationship between Chapman and Roper? I mean, he might do, but how far does one take it? We were focusing, understandably, on those who were in the management of the club at the time, those who survived. So we had the chairman, the club secretary.
You had everybody except Chapman? Everybody except Chapman,
and Hurst was his, as it were, shadow. We didn't. The criticism of the judge is to miss the point. It's the burden of proof is on a claimant to demonstrate that it's equitable to allow the case to proceed. The defendant at most has an evidential obligation to raise questions of prejudice, and having done that, that's enough.
But what you can and often do say in such cases is X is dead or unavailable, and that's prejudice or gives rise to a risk of significant prejudice, and I want that brought into account on limitation.
Well, and we did.
You did, and you do. And but in those circumstances, is a judge not obliged to make an assessment of what the impact of the missing witness may have been, and is he not, in making that assessment, obliged to take into account all the other evidence to create the context? And so then we get to his assessment that because all the evidence was going in one direction, he's satisfied that Chapman wouldn't have made a difference. Now, Pache, Mr. Justice Nichol, that is an exercise that he's entitled in principle to go through, isn't it?
Yes, but I suppose it is. But the problem is that's why we say this. If you have contrary accounts given by anonymised witnesses, then we say it would be impossible for the judge to say that Chapman couldn't have said anything different. That's what he's saying. And yet, this is why we say if you have an account, if I can do it, to make this point, we do refer to it as a skeleton argument. And the court will put it out of its mind if my application fails on this unagreed material. If a witness says, I don't think Roper had much to do with Blackpool Football Club, or he referred players to other clubs, then that demonstrates that it isn't all pointing in one direction. At that point, he's just surveying the field. He's not making any findings.
So at that stage, he doesn't need to place weight.
It's not weight, exactly.
It's
yes.
The fact that
he may have to say, well, this is just incredible. That's not a credible story.
Yes.
Someone says, I was on Mars. But if it's otherwise a plausible...
You can't dismiss it at that point.
Yes.
That's what you're saying.
Exactly, yes. Yes, I think we deal with the players in paragraph 29 of the skeleton. Which is... we're back to the late Mr. Rumsfell's unknown unknowns. And this is what we were emphasising in citing the Sir Justice Nicholl and Sir Robert McGarry that we are entitled. The starting point is we're entitled. We're dealing with a case so many years after the event to say, well, has the claimant satisfied you that really the defendant isn't significantly prejudiced? And we don't have to say, well, although we've lost our main man, Mr. Chapman, we haven't bothered to. It's not a complaint to say we haven't bothered to search through possible former players who might, and this will be entirely speculative, have had something to say beyond what Mr. Hurst or Mr. Ellis could say, or Chadwick and Johnson. So that is our point about.
And presumably the fact that these anonymised witness statements were from the police files, this was in relation to allegations of sexual abuse that had been made
rather
against
odd,
Roper?
because Roper was already dead, but I think the police do investigate.
But it was in relation to that, to the
Yes,
allegations.
exactly. I think as we understand it, yes. Allegations came out in 2016. There were a whole spate of allegations about football scouts and people of that ilk abusing boys. And it came out. And then the police did investigate. And so it comes from a proper source. The police are not likely to necessarily got it wrong. It's not hearsay of the most improbable sort. Or
When did Roper die?
2005. 2005. And the balloon went up, as it were, in 2016.
So why were they investigating? Why were the police investigating when the potential defendant was dead?
I don't know. It may be that they want to see if other people are implicated in his abuse.
Was it in relation to the inquiry that went through?
Well, there's Barry Bennell, the famous Barry Bennell, of course, who was still alive, and I think, and there is evidence, there was a suggestion they knew each other.
Mr. Futrell's dying to follow.
He wants
No,
to.
it's only to help, my lady. In answer to your question, first of all, the police do investigate even though people are dead. But in this case, it's not clear when they knew that Frank Roper was dead, and that may well be the explanation that they started to investigate before they actually found out that he was dead. So.
Your application is actually to have us look at this relatively short bundle.
Yes.
Is that right?
Well, in fact,
most of which is blacked out in a way.
Yes. We've quoted everything we want.
I'm just wondering whether it wouldn't be something that we could look at defendant, if it's not going to take very long.
Well, my lord, I wouldn't take the court to anything which we haven't quoted fully in our skeleton, in fact. So the process we are already adopting is a de beniesi one, in that if your lordships have read the skeletons, and you would have to put out of your mind those parts which refer.
So there's nothing additional in the file that you want us to look at?
I don't think
to the skeleton.
I wouldn't want to refer, my learned friend may want to if our application succeeds, but in general terms.
Makes this a rather pointless application, doesn't it? If it's all there and we've read it.
Well, we wanted it in the appeal bundle. My learned friends objected, as they're entitled to do, and the practice direction says if you can't agree bundle, then it should go in an unagreed bundle, and the matter will be dealt with by the court. And the court directed that it be dealt with at the hearing. So here we are. That's all it amounts to. But Lord, if it's
really,
all there.
what you're relying on is the number of witness statements in here that are not in accordance with the claimant's witnesses' recollections. And as my lord says, there's an awful lot of redaction, but you're just putting them in to say there was a different side of the story.
And we quote them, underground 7 in relation to stage 1 vicarious liability, and underground 8 in relation to stage 2. And we did that when we drafted the skeleton, when we had that ground 1. Lady Justice Simler having refused permission, we can't rely upon them under ground 7 and 8 because they're substantive grounds, but we cross-refer to them under ground 4, so they still have some validity.
Well, they've got a different validity, haven't they, in the limitation point as to the vicarious liability point, because you're not seeking effectively to rely upon the truth of the contents, just the fact that they were made.
Yes.
And that fact is established by the production of the statement.
Absolutely, Mary. It puts to bed any suggestion that this was that the defendant is as it were, disingenuously taking a prejudice point when everybody knows there was only one account that could ever be given. We say the accounts were many and various.
I don't think the judge said you were disingenuous.
Yeah. But that's often said against, understandably against defendants, that you're technically taking a limitation defence.
Perhaps Mr. Counsel will say it.
I'm sure he would.
I'm not sure.
He'd be more polite. Now, I think I've come to the end of my submissions. I may have missed the odd reference. I could go on for longer, but I think I've covered both the application and my submissions.
Well, we've got your skeleton argument.
Sorry, Believe.
We have your skeleton argument.
Yes, you do.
Well.
Okay. Those are my submissions.
Thank you very much. Mr. Counsel, before you proceed, Mr. Futterell, do you want to follow in any other
No,
respect?
that's very kind, Lady. I've had my say. Thank you very much.
Well, thank you very much. Mr. Counsel, I'm going to suggest that we're going to have 5 minutes just to have a
Good idea.
bit of fresh air, which is very hot even in the corridor, but I hope that's not going to put you off your stride.
Not at all. Thank you.
All right, so if we come back at 20 past, that will be 8 minutes.
Thank you.
Thank you.
No sign of the air conditioning. No sign of anybody. No.
I'll just go and form a trip again.